Athirah binti Yushri.
Assalamualaikum and hi, my name is Nur Syazira binti Khairul Azri.
Hi, my name is Nurul Izzah binti Nor Aidi.
Hi, Assalamualaikum. My name is Nur Syarmila binti Mohd Sobori.
Hello, my name is Puteri Sofia binti Humaidi.
Okay, for Islamic Financial Service Act 2013, the regulatory and supervisory framework of the financial system in Malaysia enters a new stage of its development as two companion pieces of legislation, the Financial Service Act 2013 FSA and Islamic Financial Service Act 2013 IFSA came into force on 30 June 2013. FSA and IFSA provide Bank Negara Malaysia with update regulatory and supervisory laws to take preemptive measures to address issues of concern that may have been effect on the interests of depositor and policy holders. Okay, the law allows the effective and efficient functioning of financial intermediation. Okay, to introduce FSA and IFSA, several separate laws, namely the Banking and Financial Institution Act 1989, BAFIA, Islamic Banking Act 1983, Insurance Act 1969 IA, Takaful Act 1984, Payment System Act 2003, and Exchange Control Act 1953 were merged into either FSA or IFSA. Okay, the individual laws were repealed on the same date when FSA and IFSA came into force. The key features of the new legislation include greater clarity and transparency in the implementation of administration of the law. This includes clearly defined regulatory objective and accountability of Bank Negara Malaysia in pursuing its principal objective to safeguard financial stability, transparent triggers for the exercise of Bank Negara Malaysia's power and functions under the law, and transparent assessment criteria for authorizing institutions to carry on regulate financial business and for shareholders' suitability. A clear focus on Sharia compliance and governance in the Islamic financial sector. In particular, the IFSA provides a comprehensive legal framework that is fully consistent with Sharia in all aspects of regulation and supervision, from licensing to the winding up of an institution. Provision for different regulatory requirements that reflect the nature of financial intermediation activities and their risk to the overall financial system. Okay, provision for different regulatory requirements that reflect the nature of financial intermediation activities and their risk to the overall financial system. Provision to regulate financial holding companies and non-regulated entities to take account of systemic risks that emerge from the interaction between regulated and unregulated institutions, activities and markets. The Minister of Finance may subject an institution that engage in financial intermediation activities to ongoing regulation and supervision by Bank Negara Malaysia if it poses or is likely to pose a risk to overall financial stability. Okay, strong business conduct and consumer protection requirements to promote consumer confidence in the use of financial services and products. Strong provision for effective and early enforcement and supervisory intervention.
Okay, for objective of the FSA 2013, the main objective is to promote financial stability. Some objectives that underlie FSA are safety and soundness of financial institution, integrity and orderly functioning of the money market and foreign exchange market. On the other hand, another objective, it is safe, efficient and reliable payment system and payment instrument. Fair, which means responsible business conduct of FIS, protect the rights and interests of consumers. Okay, for objective of the IFSA 2013, the main objective is to promote financial stability and compliance with Sharia. Thus, it is for safety and soundness and financial institution integrity and orderly functioning of the money market and foreign exchange market. On the other hand, another objective, it is safe, efficient and reliable payment system and Islamic payment instrument. Fair, which means responsible business conduct of FIS, protect the right and interests of consumers.
Next, regulation of shareholding. First, acquisition of interest in share. Licensed person under the FSA to obtain a license to carry on banking business, insurance business or investment banking business. And under the IFSA, it refers to a person who is licensed to carry on the Islamic banking, takaful business, international Islamic banking business or international takaful business. In Schedule 3, it defined as the lender and the beneficiary interest in share. Purchasing a 5% interest after inter-agreement need BNM approval before into an agreement. The policy is applicable to a person that is required to obtain an approval pursuant. Second, control over a licensed person. Section 88 of the FSA and Section 100 of IFSA for who was taking a license, a controlling is at least 50% or more of the outstanding share, or when a shareholder holds majority of a company voting stock. Third, disposal of interest in share. FSA and IFSA also require a person who has aggregate interest in share of license that present more than 50% or less but have control over the license. BNM will monitor financial groups for safety and ensure a licensed person safety. Next, consumer protection. Part 7 of the FSA and Part 8 of the IFSA include various consumer protection clauses. BNM specific standard for corporate behavior for financial service provided that they treat customer fairly and professionally. Section 124 of the FSA and Section 136 of the IFSA prohibited service provider from participating Schedule 7 of the business conduct like prohibited business conduct misleading and deceptive conduct. Lastly, financial advisement scheme. Consumer protection under FSA and IFSA, one of their strengths is ensure effective and fair handling complaint service. Each financial services provider who wants to be member of the financial advisement scheme and comply with the terms of its membership.
Now, I will explain on the summary of differences between IFSA 2013 and FSA 2013. As you can see, the table on the side shows briefly the differences between IFSA and FSA 2013. It covers from definition, scope of activities, grounds for revocation of authorization, Sharia requirement, related parties, giving priority to Islamic depositors and IAN instead of shareholders, and preparation for accounts. From this table, I conclude that IFSA 2013 focused more on Sharia compliance and governance in the Islamic financial sector compared to FSA 2013. Even so, we need to keep in mind that both were created for their respective objectives. Next, the Parliament of Malaysia has enacted the FSA and IFSA 2013. The acts were published in the Gazette on 22nd March 2013. It includes financial holding company restructuring, corporate restructuring, audit compliance, individual shareholding limit, and talent requirement. Next, we move to the differences between IFSA 2013 and Takaful Act 1984, or mostly known as Insurance Act. From this table, I conclude that IFSA and FSA 2013 are more updated than Takaful Act. There are many advantages in favor of IFSA and FSA 2013.
Now, I will explain the Sharia requirement for Islamic financial institution. The requirement is Central Bank of Malaysia Act 2009. The Act was passed to provide for the continued existence of the Central Bank of Malaysia and for the administration, object, function and powers of the bank. For consequential or incidental matters, the most significant provision of the newly passed legislation is Part 6 under the heading Islamic Financial Business. Part 6 is divided into two chapters, including Chapter 1, Sharia Advisory Council, and Chapter 2, Power of the Bank. Part C is directly provided for the Islamic financial business, which is defined under Section 2 as any financial business or ringgit or other currency which is subject to the law enforced by the bank and consistent with the Sharia. The Sharia Advisory Council on Islamic Finance shall be established by the Central Bank of Malaysia by virtue of Section 51, and the Council shall be authority for the assessment of Islamic law. The Council is given authority to determine its own procedures in carrying out their duties under the Act. Next, I will explain the function of Sharia Advisory Council. The function of the Sharia Advisory Council are listed under the Section 52 and including the ascertains the Islamic law on any financial matter and issue a ruling upon reference made to it in accordance with Part 6 of the Act. Second, to advise the bank on any Sharia issue relating to Islamic financial business, the activities or transaction of the bank. Third, to provide advice to Islamic financial institution or any other person as may be provided under any written law in force in Malaysia. Fourth, such other function as may be determined by the bank. The members of the Sharia Advisory Council shall be appointed from amongst persons who are qualified in the Sharia or who have knowledge or experience in the Sharia and in banking, finance, law or such other related disciplines, and the appointment shall be made by the Yang di-Pertuan Agong on the advice of the Minister of Finance after consultation with the Central Bank as provided by Section 53. Section 55 further stipulates that the bank shall consult the Sharia Advisory Council on any matter relating to Islamic financial business and for the purpose of carrying out its function or conducting its business or affairs under this Act or any other written law in accordance with the Sharia, which requires the ascertainment of Islamic law by the Sharia Advisory Council. Section 55(2) also provides that any Islamic financial in respect or its Islamic financial business may refer for a ruling or seek the advice of the Sharia Advisory Council. Now, I will explain the requirement for reference to Sharia Advisory Council. For the first ruling from court or arbitrator is expressly provided in Section 56(1), which states that wherein any proceeding relating to Islamic financial business before any court or arbitrator, any question arises concerning a Sharia matter, the court or the arbitrator, as the case may be shall first take into consideration any published ruling or the Sharia Advisory Council. The second is refer such question to the Sharia Advisory Council for its ruling. The provision requires the judge or arbitrator who is presiding over any dispute arising from Islamic financial business to refer to the published ruling of the Sharia Advisory Council or to request for advice from the council to determine any issues concerning a Sharia matter before them. In case of conflict between a ruling issued by Sharia Committee of an Islamic financial institution and a ruling issued by the Sharia Advisory Council, the ruling of the Sharia Advisory Council shall prevail and be as applicable.
The provision clearly states that any ruling made by council will be binding on the civil court and the arbitrator, which means the court and the arbitrator must follow the ruling to arrive at their decision, and the ruling shall form part of the judgment of the court in Islamic banking and finance cases. The new legislation is intended to resolve the issue which have arisen before the coming into effect of the Act, especially the legal effect of the ruling issued by the Sharia Advisory Council. However, there still exists certain issues which need to be addressed, such as the issue of responsibility and equality, and most important, public perception towards Islamic banking, product and Islamic financial. In 2005, the Central Bank prepared the guidelines on the governance of Sharia Committee for the Islamic financial institution that regulates the governance of Sharia Committee of an Islamic financial institution. These guidelines shall be applied to all Islamic financial institutions regulated and supervised by Malaysia Central Bank, including firstly, the Islamic Bank License under the Islamic Banking Act 1983 IBA. Secondly, Financial Institution License under the Banking and Financial Institution Act 1989 BAFIA, which participate in the Islamic banking scheme BAFIA IBS Bank. Thirdly, development financial institution prescribed under the Development Financial Institution Act 2002 (DAFIA), which carry on Islamic banking scheme. Fourth, takaful operator registered under the Takaful Act 1984 (TA). The guideline has now been superseded by the Sharia governance framework for the Islamic financial institution, which was issued by the Central Bank in January 2011, which required all Islamic financial institutions to comply with the framework within a 6-month period of the date of its issuance. The framework is divided into 6 sectors, which are Section 1, General Requirement of the Sharia Governance Framework, Section 2, Oversight, Accountability and Responsibility, Section 3, Independency, Section 4, Competency, Section 5, Confidentiality and Consistency, Section 6, Sharia Compliance and Research Function. The framework required that the Sharia governance framework of an Islamic financial institution shall consist of the board oversight on Sharia compliance aspect of the Islamic financial institution's overall operation. The framework required that the Sharia governance framework of an Islamic financial institution shall consist of the board oversight on Sharia compliance aspect of the Islamic financial institution's overall operation. The Sharia Committee shall be responsible and accountable for all its decision, view and opinion related to Sharia matter. The Sharia Committee is expected to disclose sufficient information in the Islamic financial institution annual financial report on the state of compliance of the institution. A credible Sharia governance structure that promotes integrity and confidence. Malaysia's experienced proper governance provides multi-layer assurance on Sharia compliance. Firstly, Sharia Advisory Council gives legislative structure as highest authority Sharia matter in Islamic finance. Secondly, accountability of Sharia Committee of IFIs on decision, view and point related to Sharia matters. Thirdly, timely disclose on fatwa ruling. Part 7, Chapter 1 of Bank Negara Malaysia Act 2009 BNM Act. Firstly, Section 51, Sharia Advisory Council on Islamic Finance SAC shall be the authority for the ascertainment of Islamic law for the purpose of Islamic financial business. Secondly, Section 52, functions of the SAC are as follows. Firstly, to advise BNM on any Sharia issue relating to the Islamic financial business, the activities or transaction of BNM. Secondly, to provide advice to any Islamic financial institution or any other person as may be provided under any written law. Section 57, any ruling made by the SAC pursuant to a reference made under this part shall be binding on the Islamic financial institution under Section 55 and the court or arbitrator making reference under Section 56. Section 58, where the ruling given by the Sharia body or committee constituted in Malaysia by an Islamic financial institution is different from the ruling given by the Sharia Advisory Council. The ruling of the Sharia Advisory Council shall prevail.
Last but not least, I will explain the comparison with Section 16 of the old BNM Act 1959. Any ruling made by SAC pursuant to a reference made under paragraph 8b shall, for the purpose of the proceeding in respect of which the reference was made, if the reference was made by court, be taken into consideration by the court in arriving at its decision, and if the reference was made by an arbitrator, be binding on the arbitrator. Section 2 IFSA, definition of property, implication to asset structures. Under Section 2 IFSA, property means any movable or immovable property, whether tangible or intangible, and includes any securities including any stock, share and fund. Definition of provision of finance is implication to product structure. Under Section 2 IFSA, provision of finance means entering an arrangement for another person to enter into the business or activity which are in accordance with Sharia.
The last part is Islamic deposit. Islamic deposit can be defined differently, which is previously under IBA, under PIDM Act 2011, and now under IFSA. Previously under IBA, Islamic deposit means a sum of money worth received by or paid to any person under which the receipt and repayment shall be in accordance with the terms of an agreement made under any Sharia principle or any basis including custody or profit sharing. As it is under PIDM Act 2011, Islamic deposit means sum of money or monies worth received or paid on terms by any person under which the receipt and repayment shall be and in accordance with the terms of any agreement consistent with the Sharia on any basis including custody or profit sharing. Now under IFSA, Islamic deposit means a sum of money accepted or paid in accordance with Sharia on terms under which it will be repaid in full or whereby the proceeds to be paid shall not be less such a sum of money.